Good morning. Are you Jonah Ray Johnson?
Yes, Mom.
And this is 25 DCCR 1775. Mr. Johnson is charged with aggravated assault with a deadly weapon. And Mr. Vasquez has filed a motion asking that I reduce Mr. Johnson's bond, which is currently set at $300,000 in that case. Are you calling your client?
Yes, Your Honor.
Mr. Johnson, best you can, raise your right
Oh,
hand.
no, I'm sorry, Your Honor. I'm not. I'm calling my client's mom, Jacqueline Broussard.
Ms. Broussard? Mr. Johnson, if you'll just come around just to the side, right there on the corner. Ma'am, if you'll come right over here, please. Good morning. And would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. You may proceed.
Thank you, Your Honor. Ms. Broussard, state your name for the record, please.
Jacqueline Broussard.
And you've done this before, haven't you?
Yes, ma'am. Oh, sir, sorry.
And you are Jonna's mom, correct?
Yes,
And the original bond back in September was $150,000. Wasn't that correct?
yes, sir.
And what went wrong? What was the problem there?
The ankle monitor, we thought it was broken, which we was led, that was, we called, Johnny, and Johnny told us to come in, which we had been talking with Johnny for 2 weeks. But like I say, Johnny said, come in, and something's going on with the monitor. And we also was a payment behind.
Okay.
But we,
let me interrupt.
I'm sorry, go ahead.
That's all right. The bondsman said the defendant has failed to pay for the GPS device. It wasn't charged. He will not respond to surety's attempt to reach him. He cannot be located. Surety feels like his bond is at risk. Now, you disagree with that, right?
Yes, sir.
The bond was never at risk.
No, sir.
Jonna lives with you.
Yes, sir.
You live in Beaumont
Yes, sir.
with your husband.
Yes, sir.
And how many people live in that house?
Me, my husband, my oldest son, and Jonah.
And how long have you been in that home?
Over 5 years.
And the four of you lived there.
Yes, sir.
Was Jonah working when all this happened?
Yes, sir.
Where was he working?
He was working for Jefferson nursing home.
Say it again.
Jefferson.
What was he doing?
He was working in the kitchen.
And how long did he have that job? You recall?
I think he had just received that one over there. Maybe 6 months. I'm not. Yeah. Because he just got hired out over there.
And he's 18.
Yes.
He lives with you. He's not. Is he a flight risk?
No, sir. He's not.
Are you worried about him taking off or running
No,
off?
sir. I'm not.
And you wouldn't waste your money if you.
No, sir. I wouldn't.
What bondsman have you talked to?
I had talked to a professional with Kenya, and I had talked also LRE with Lisa.
Which bondsman was this back in September?
I think that was Ella.
That was Ella.
Uh-huh.
Is that who you're talking to now?
Yes, one of them, yes.
And what have your conversations been like with them?
They just ready for me to get in touch with them and see if they're not gonna be reduced. I just had one text me this morning.
Have you talked to them about what amount you would want that you're trying to get reduced to? What would be reasonable?
At least 100,000. We had talked on that.
Well, it was 150,000 back then.
Yes, sir.
So it's not really realistic that that the court would drop to 100,000 now.
Mm-hmm.
Are you asking the court to reinstate I don't know if reinstate the correct word, but to go back to the $150,000?
Yes, sir. Yes, sir.
Is that something you think you could work with?
Yes, sir.
They probably want you to sign a contract for $15,000.
Yes, sir.
I think 10% is the one.
Yes, sir.
Would you make sure there was no discrepancies or mistakes or misunderstandings about the GPS monitor system?
Yes, sir.
And what else would you like to tell the judge about the bond?
About the one. We are ready prepared to make fun, John.
Have you seen the video in this case?
Yes, ma'am.
Okay.
I have talked to my son. Yes, ma'am.
You've actually seen it?
Yes, ma'am.
Okay.
The whole video.
Okay. Anything else?
Nothing else, Your Honor.
That was
Questions of this
that was
witness?
actually one of my questions.
Up until this moment, everything feels familiar, almost predictable. A young defendant, just 18, living at home, working a job, with a mother standing behind him trying to convince the court that he's not a risk. And honestly, if you stop the video right here, you might actually believe her. You might think this is just another case of someone who made a mistake and deserves a second chance. But this is exactly where courtroom reality tends to hit the hardest. Because what families see, and what the court sees, are often two completely different stories. A mother sees her son, the kid she raised, the one who still lives under her roof. But the court sees patterns, history, risk, behavior over time. And the moment the prosecutor starts asking about his past, everything changes. This isn't just about one incident anymore. This becomes about who he's been, and whether that history can be trusted not to repeat itself.
I was going to ask this witness as whether or not she's seen the video, Judge.
Okay.
In addition to that, Ms. Broussard, are you aware that your son in the last 5 years has been arrested for 9 different offenses?
Excuse me?
Are you aware that in the last 5 years your son has been arrested for 9 separate offenses?
9?
Yes, ma'am. Evading arrest as a juvenile, UUMV as an adult, possession of a controlled substance, unlawful carry of a firearm, failed to ID, possession of a controlled substance, possession of marijuana, and 2 additional unauthorized carrying of a weapon. Were you aware of those arrests?
Yes.
Okay. Now, the gun that your son allegedly carried back on August the 31st of 2025, during that shootout at the Pine Club Apartments, do you have any idea where you got that gun from?
No, sir.
Are you aware that a bystander was shot during that melee?
Yes, sir.
All right, that's all I have, Judge.
Okay, any other questions of this witness?
No, Your Honor.
Thank you, ma'am. You can have a seat.
Thank you, ma'am.
Any other witnesses, Mr. Vasquez?
No, Your Honor.
Mr. Coleman?
Judge, one of the items of evidence that I plan on introducing was the video from the shootout. It sounds like the court vividly remembers that. So if the court doesn't wish to see that again, I want to.
And just like that, the entire tone of this hearing shifts. 9 prior offenses in 5 years. Weapons charges. Drugs. Evading arrest. And now, a shootout where a bystander got hit. That's not a misunderstanding. That's not a one-time mistake. That's a pattern. And you can see it in the room. The energy changes. The sympathy starts to fade, and reality steps in. Because now the judge isn't just thinking about this young man's future, she's thinking about public safety. That one detail, an innocent bystander being shot, that's the kind of fact that stays with a judge. It changes how every decision is made after that. And suddenly, the mother's words, they don't carry the same weight anymore. Because no matter how much she believes in him, the record is telling a very different story.
Let's just quickly play it. I want to, I'm refreshing my memory by taking, well, first of all, I'm going to take judicial notice of the court's file. I have reviewed the probable cause affidavit, which is what reminded me of the facts of the case. And I guess it was the other
It was the
case that
co-defendant.
we had a bond hearing on. Is
Yeah,
that
yeah.
correct?
Well, no, I take it back. It was this defendant when he was represented by Brittany Holmes, if I'm not mistaken.
So I've had a bond hearing, watched the video on this case.
Yes, Judge, if I'm not mistaken. In fact, when you look at my notes, that would have been January 13th of 2026. My notes include that there was a defense motion to reduce the bond. We argued, you heard evidence and testimony, and that you denied the motion back in January of this year.
So this was after the AFRS, and the bond was at 300,000 on that date for the same bond hearing.
Yes, Judge.
Your motion's denied. I've already heard all the evidence.
There is something, Judge. I think that it's at least, if you're going to deny it, I think you may want to consider it as far as whether or not the bond is sufficient. As it states, it's just a 5-minute clip of
Go ahead.
a jail phone call.
Maybe report it or monitor.
Some of that shit, right? 25. She said, I said, bitch, he came back in. He said, like, still ain't gave probation. The lawyer told they were going to give probation and shit. I was actually looking at the lawyer trying to ask probation and shit. She was like, man, there's too much shit be going on. It's like a wild, wild west. You know, he come up, she was like, you got right up, you be jumping in and that little shit. But she like, I gotta make an example. But, yeah, oh my man, crazy. People went crazy for me. Wow. No, he said people screaming that shit. They say, man, world star type of shit. But bro, all over the world, all the things. But a couple days later, first it was cool, he was chill. Kept like, bitch, you good, you good, sure you good, bitch, and they good. Like, I'm good with whoop. So one day, he just snapped. CO said something to him. They said, what, bitch, what the fuck? So I get to CO and they want to punch you. They gonna like, 6 weeks. Whoop. Niggas, he ain't trying to CO and trying to punch like, boom, he smacked the motherfucking computer, punched that bitch. Break the motherfucking computer. They come, he been in hand though, man, since they came out, I thought he been in hand though. That bitch 25, so it was trick so good. Good. Hey, bitch. Anyway, you gotta do at least one test. I mean, God, his taxes. If you go down that trip, he gonna put it up for college for five. Yeah. And they know it's his whole point. That's my little folks. Good, I had question about you want to leave your sentencing to the judge? And I said, hell nah. Take my shit to trial. I said, then boom, I got my bus for the governor. I seen all my evidence and shit. That shit bullshit, bro. Let me take this to trial, bro. They gonna drop the charge. So shot up, take the trial. Ooh, my lawyer's good. Now he look at the paperwork and shit like, oh, you good? You feel? You give him time. Like, I know it's gonna take time. Because everything that's going on right now, they ain't making it no better. My shit, but like I say, they come, even if they come like this, 5-year cap, they gonna say they off probation with a 5-year cap. I take that. I want to be careful. I want it 5 years. But if they do, I put like 2.5 on that bitch. Oh, come on, man, brother. Thank you. I have some bank time. Get fed. I'm gonna have some bank time. Sorry, got 5 months bank time right now. You mean that 5 months? 5 months, bitch. Damn. But this was 5 months. 2 months I did, boy, this shit look like shit over. Very good points of the phone, because I think when I really kind of been flying by. It's just like, once you get in, it's going to just flying by. Sure. That shit. Very bitch, this shit so lame. Wow, this is something. I ain't a mother, but this shit very bitch. Something. And cause nigga been around young niggas be so hard to do, I stay out the way. But you know, push gonna come to shove or some shit gonna happen. Boom, you know. Get to the like that was my first write up. Like bitch, I've been chilling, so I've been quiet, doing that to nobody. That there's just write up, got another write up, I got fighting write up, other fight or something. But I think they moved to this door. Shit. It was check out to the top. So I put me on games that so it's going on like shit. So first I guess it was my first 10 minutes, so I was gonna carry up boom. I think it's coming out of leave and go back. You know, there's gonna be a lot of people like this. I'm good. I'm back and I can't back to this. Right? So I'm like, yeah, oh, something done. They can get out this whole like the flood. You see it, you know. I ain't gonna figure the world like this. It has to be good. Maybe I also shit say give a nigga probation for worse shit like that. Good. This how I know you come out on top with you probation for when you they just gave my other part of my free world project nigga had 3 robberies. Hey, gave nigga ISL for 3 months and 10-year probation. That's like that nigga you can't believe. That's what I'm talking about. They gave ISL 3 months. I had 3 months ISL he got 10 years probation. After he was already on probation, 10 years. But crazy, him and the dude that got fight with the court the same day.
That's all I have on that, Judge. State has no further witnesses.
At this point, the outcome almost feels inevitable. The judge has already seen the video. She's already heard this case before. And now, after everything we've just heard, the history, the violations, the failure to follow basic bond conditions, it's hard to imagine this going any other way. And that's something people don't always understand about bond hearings. This isn't about guilt or innocence. It's about trust. Can the court trust you to follow rules? To show up? To not put others at risk? And in this case, that trust has already been broken. Multiple times. So now, the decision isn't just about giving someone a chance. It's about whether they've already had too many.
All right, anything else?
No, Your Honor.
Okay. So at this time, I am going to deny the motion for a bond reduction. And I guess, Mr. Coleman, depending on any future incidents, if the state wishes to file a motion to increase, I would look at that at the appropriate time.
We have contemplated that, Judge.
But Mr. Johnson, a condition still, if you make that $300,000 bond, is that you would be on house arrest. You would be required to wear a GPS monitoring device at all times. Part of the reason that I'm doing this is because it sounds like you were working, your parents have the issues. I've looked at the bond, the affidavit for them to release surety. It's not just the GPS monitoring device. They obviously were having a hard time getting in touch with you for whatever reason. So I think that makes obviously one of the criteria under 17.15 for bail is that obviously you have to follow all of the rules and conditions of bond, which is with your bondsman as well. And so we will reset your case for an announcement, and Mr. Vasquez will visit with Mr. Coleman, get any offers in your case, and we'll either take a plea if you wish to take a plea at the next court date, or if you don't, we'll do a rejection and get your case set for trial. All right, you can go back with the bailiff.
This is one of those cases that sits right in the grey area between sympathy and accountability. Because on one hand, you see it, he's young. He has a family that clearly cares about him. There's structure there, opportunity there, a path that could have gone differently. But on the other hand, the pattern is undeniable. 9 prior offenses, weapons, violations, and now a situation where someone completely uninvolved ends up getting shot. That's the part that's hard to ignore. Because at some point, it stops being about potential and starts being about responsibility. And the judge's decision here reflects that balance. She didn't escalate it. She didn't punish beyond what was already set. But she also didn't reward behavior that showed a lack of compliance and accountability. The $300,000 bond stays. The GPS stays. The restrictions stay. Because in the court's eyes, trust isn't something you ask for. It's something you prove. And right now, he hasn't proven it yet. So the real question moving forward isn't what the court will do next. It's whether he finally breaks the cycle, or becomes another example of it.